Hello, dear friends. Welcome back to Jurist Lens. Today we shall discuss about evolution of intellectual property rights, importance of human creativity in present scenario, and different forms of intellectual property and its conceptual analysis. Friends, have you ever had an amazing idea? Maybe a new app, a design for a product, or even a book you want to write. But how would you feel if someone else copied your idea without giving you credit? That's where intellectual property rights or IPR come in. IPR is all about protecting your ideas, inventions, and creative works. The story of IPR began centuries ago in the 14th and 15th centuries. But back then, if you came up with an invention, there was no law to protect it. You could invent something incredible and someone else could take your idea without any legal consequences. Can you imagine how frustrating that must have been? So why didn't inventors have protection back then? Was it because they didn't value their ideas? Or was it just that the concept of protecting ideas was not yet developed? What do you think? It wasn't until 1624 that we saw the first real law to protect inventions. Queen Elizabeth I passed the Statute of Monopolies. This law gave inventors exclusive rights to their inventions for a limited period. So if you invented something, you would be the only one allowed to profit from it and others could not copy your work. For example, let's say you come up with a new phone case design. Without IPR protection, someone could easily copy it and sell it as their own. But with IPR, you have the right to stop them from stealing your idea and make sure you are the one who benefits from your hard work. Imagine you are an inventor today. How would you protect your creative ideas in the modern world? Would you patent them? Would you trademark your designs? Or maybe you would focus on copyrights to protect your writings or artwork. For example, think about the apps that you use every day. If someone copied the design of your favorite app and released it as their own, you would probably want to report them, right? That's a trademark infringement. Or imagine your favorite movie being uploaded illegally online. That's where copyrights step in to protect the creator's rights and make sure they get paid for their work. Whether you are an artist, an inventor, or a writer, understanding IPR can help you to protect your hard work and creativity. And who knows, your next big idea could be the one that changes the entire world. Having said this introduction, now let's understand the evolution of IPR. Copyright in England, a historical overview. Dear friends, it is the early 16th century, books are very rare and expensive, and copying them by hand is a laborious task. But then something revolutionary happens, that is the invention of the printing press. This one invention changes the game, and with it, the birth of copyright law begins. As the printing press gained popularity in England, a new industry started to emerge. Printers and booksellers, known as stationers, became the driving force behind this new wave. But they needed protection for their creations. To get back their investment, they turned to the crown, seeking exclusive rights to print and distribute their works. By the early 1700s, things were changing fast. In 1709, the Statute of Anne was passed. This first ever copyright law shifted the power from printers to authors, granting them exclusive rights to print and distribute their works with the possibility of renewal. This law laid the foundation for authors' right, ensuring creators could control how their works were used and distributed. Imagine this, someone writes a book, pours their heart into it, and suddenly others start copying and selling it without permission. Without copyright protection, this could happen to any writer. The Statute of Anne protected the author's right to control their work, putting a stop to unauthorized copying and ensuring they could earn from their creation. But not everything was a smooth sailing. In the 1774, a case of Donaldson versus Beckett, a landmark decision was made. The House of Lords ruled that Authors retained the right to control their works even after publication. However, once a book entered the public domain, it was free for anyone to use. This decision helped to clear up the confusion between common law and statutory copyright, ensuring the ownership of creative works. The Statute of Anne was just the beginning. As technology advanced, so did copyright protection. With the rise of photocopiers, computers, and digital media, copyright law expanded to cover these new ways of reproducing and distributing creative works. It wasn't just about books anymore. The law now had to protect films, music, and even digital content. By the 19th and 20th centuries, the concept of copyright spread across the globe. With the advent of international treaties, countries began to recognize authors' rights everywhere. The principles laid out in the Statute of Anne still form the core of modern copyright laws around the world. From its humble origins in 1709, copyright law has grown to protect creators of all kinds, such as the authors, musicians, filmmakers, and digital creators. Today, whether someone writes a book, composes a song, or creates content online, their work is protected by the same foundational principles that started with the Statute of Anne. Evolution of patent. Let's step back to the 12th century in England, a time when royal grants, known as a letters patent. Letters patent were issued to encourage innovation. These were public documents sealed by the king, offering special rights or monopolies to individuals, sparking a journey that would shape the future of intellectual property. So these letters patent were designed to promote technological progress. The idea was simple: rewarding inventors with exclusive rights for their inventions, encouraging innovations in areas like manufacturing and industry. This laid the foundation for modern patent law. By 1624, the Statute of Monopolies was enacted, marking the first true patent law in England. For the first time, inventors were granted exclusive rights to their creations for up to 14 years. This law formalized the patent system not just in England but influenced countries across the globe. Dear friends, as England entered the Industrial Revolution, a wave of technological advancements led to even more inventions. The need for a stronger patent system grew. New machines, chemical processes, and medical devices were being invented, and patents began to cover a broader range of creations. In 1852, the Patent Law Amendment Act was introduced, making the patent application process more accessible. This allowed more inventors and entrepreneurs to secure protection for their innovations. The patent system was becoming more inclusive and streamlined, helping to fuel industry growth. Today, the patent system in England is governed by the Patents Act 1977. It remains aligned with international agreements like the European Patent Convention and the TRIPS Agreement, ensuring that inventors are worldwide protected. From royal grants in the 12th century to today's global intellectual property landscape, England's patent system has evolved to encourage and protect innovation. Patents continue to drive technological advancements, benefiting society and shaping the future. Trademarks in England. A historical overview. Dear friends, trademarks have been around for centuries, serving as a mark of origin. Long before modern law, artisans and manufacturers in ancient cultures used unique symbols or initials on products like bricks, leather goods, weapons, and cookware. These marks led to consumers recognize the maker, ensuring quality and authenticity. In England, during the Middle Ages, the use of trademarks began to formalize, especially with the rise of trade guilds. These guilds regulated product quality, requiring their members to mark goods with the unique symbols. This system ensured the products to meet certain standards, and trademarks became a way to signal reputation and quality. With the Industrial Revolution came mass production, and as a market grew, so did the competition. The need for distinguishing products became crucial. In response, England took steps to formalize trademark protection. In 1875, the Trademarks Registration Act introduced the first formal trademark register in England. Businesses could now officially register their marks, providing legal protection from unauthorized use. This was a major step in recognizing the value of brand identity in an expanding marketplace. Global influence, America and trademarks. The US played a key role in shaping global trademark law. After gaining independence, America became a growing political and economic power. In 1946, the Lanham Act set the foundation for modern trademark law in the US, strengthening global trademark protection. International treaties and global trademark system. As international trade grew, treaties like the Madrid Agreement allowed businesses to register their trademarks across multiple countries with a single application. This interconnected the global trademark system, simplifying international trademark protection for businesses worldwide. Now let's understand the patent system in the United States. A historical overview. The foundation of the US patent system can be traced to the very first article of the US Constitution. This article aimed to promote science and the useful arts, granting Congress the authority to secure exclusive rights for authors and inventors. But how did this constitutional vision evolve into one of the world's most influential patent system? The first Patent Act. In 1790, Congress passed the first patent statute, creating the legal framework for intellectual property protection in the US. This was the starting point for a patent system that would encourage innovation and shape the country's economy. By 1836, the US Patent Office was established to manage patent applications and grants. This systemized process allowed inventors to legally protect their inventions, fueling the growth of innovation and the American economy. While the US was influenced by the British patent system, it introduced its own unique elements, including broader patentable inventions and a specialized patent office. The US aimed to create a more accessible and transparent system for inventors to safeguard their creations. The Plant Patent Act of 1930. In 1930, the Plant Patent Act introduced a new category of patents specifically for new plant varieties. This reflected the growing importance of agriculture and plant breeding in the US economy, expanding the scope of patent protection. The 1952 amendments brought major changes to the US patent law, refining the patent application process and introducing clearer standards for novelty and non-obviousness. These changes made the system more efficient and adaptable to the rapidly growing US economy. The US patent system grants exclusive rights to inventors for up to 20 years. This strong protection encourages research and development, making the US a leader in the fields like pharmaceuticals, biotechnology, electronics, and aerospace. Now let's focus on major development in the growth of IPR. The Paris Convention of 1883. The Paris Convention for the Protection of Industrial Property, signed in 1883, made it easier for inventors and businesses to protect their patents, trademarks, and designs across multiple countries. It provided a unified system for intellectual property protection. For example, if a US inventor wanted to protect an invention in Europe, the convention allowed them to file once and extend protection in other countries. The Berne Convention of 1886 and copyright. While the Paris Convention focused on industrial property, the Berne Convention protected copyright, ensuring creative works were automatically protected across member countries without needing to register. The Paris Convention and other treaties have adopted today's digital age. New laws like those for digital signatures and electronic contracts make it easier to protect digital innovations. So the Paris Convention was a game changer for intellectual property, laying the groundwork for today's global system. As technology evolves, IP protection continues to adapt, safeguarding innovation worldwide. Now let's focus on evolution of intellectual property rights in India. In ancient India, intellectual property was not formalized, but respect for creative works was deep rooted. Works like the Vedas and Upanishads were highly respected, and innovations in fields like mathematics and medicine were considered personal treasures. Intellectual creations like the Mahabharata were treated as valuable. Inventions in astronomy and medicine were honored but not legally protected. The Aryabhatiya, an ancient mathematical work, was treated as a valuable intellectual creation even though there was no formal patent system in place. In medieval India, intellectual property protection remained informal but continued to be a part of society, especially in art and craft. Artisans and traders protected their techniques, but legal system for IP were absent. The Mughal and Persian rulers recognized intellectual achievements, offering informal protection but no legal framework. For example, the textile industry in pre-colonial India was known for its highly specialized designs, which were often protected by family-based guilds. In the 19th century, the British brought formal intellectual property laws to India with framers for patents, copyrights and trademarks. The Indian Patents and Designs Act of 1856 was introduced, but it mainly benefited British colonists. The Copyright Act of 1911 was based on British law and focused on European works. The Trademark Act of 1940 set the stage for protecting brands and logos. The Indian Patents Act of 1856 marked the beginning of formal IP laws in India, though it was largely designed to benefit British inventors. After independence in 1947, India began to develop its own IP system. A focus on self-reliance and the growth of domestic industries led to significant changes in patent and copyright law. Indian Patents Act of 1970 abolished product patents for medicines, making drugs affordable for the public. Copyright Act of 1957 modernized copyright protection to include more types of creative works. The TRIPS agreement came into effect in 1995, requiring India to align its IP laws with international standards, especially as the global economy became more integrated. Patent reform in 2005. India introduced product patents for pharmaceuticals aligning with international norms. The Geographical Indication Act of 1999 protected traditional products like Darjeeling tea and basmati rice. In 2016, India introduced its national IPR policy to build a more robust and innovation-driven IP ecosystem, promoting research and development. India's national IPR policy aimed to create a culture of innovation, supporting industries in sectors like biotechnology, pharmaceuticals and software. Now let's concentrate on importance of human creativity in present scenario. Dear friends, alright, imagine this. A world without creativity. Sounds boring, right? No new inventions, no movies, no new songs and no new technology. Creativity is what shapes our world. It is how we come up with new ideas, new products and even new ways of thinking. So what is creativity? Creativity is like the spark that starts a fire. It is the idea behind a new app that you use every day, the latest blockbuster movie that you watch. But just having creativity is not enough. It needs protection so others do not take it without your permission. So how IPR protects creativity? This is where intellectual property rights come in. IPR is like a shield that protects your creative ideas from being copied. If you come up with a new idea, like a new invention or an artwork, IPR gives you the right to say, hey, this is mine, and stop others from using it without your permission. Then why is this important? Well, think about this. If someone else could take your idea and make money from it, you might not feel motivated to create anything new, right? IPR makes sure that the creators get rewarded for their work, which encourages more people to come up with new ideas. By protecting these new ideas, IPR helps to innovate. That means new technology, gadgets, the latest music, better medicine, and even the clothes we wear. Every time someone invests or creates something, IPR makes sure they get credit and a chance to profit from it. This creates a cycle where innovation keeps growing. Think about all the companies you know, such as Apple, Nike, and Coca-Cola. These companies are built on creativity and their trademarks, patents, and copyrights are protected by intellectual property rights. Now let's explore the different forms of intellectual property and their conceptual analysis. First up is copyright. Copyright protection is given to creators of original works of authorship. This could be books, music, films, and even software. It is like a shield that keeps other people from copying your work without your permission. For instance, if you write a novel, it's automatically protected by copyright and no one can copy your story without your approval. Think about famous authors like J.K. Rowling. Her Harry Potter series is protected by copyright. The main goal of copyright is to encourage creative works by giving the exclusive rights to use and profit from their work for a certain period. Next we have patents. Patents protect inventions, anything new and useful like a new type of technology, device, or even a pharmaceutical drug. For example, remember when Apple launched the first iPhone? The design and technology behind it were patented, which means no one could copy their exact phone or technology without permission. A patent gives the inventor exclusive rights to make use and sell their invention for up to 20 years. It is a way to reward innovation and keep others from copying inventions. Now let's talk about trademarks. A trademark is any word, logo, or symbol that distinguishes products or services from others. For example, Mercedes-Benz star logo. The three-pointed star logo of Mercedes-Benz is a registered trademark. It represents luxury and quality in the automotive industry, and only Mercedes can use this logo on its cars and related products. Trademarks ensure that consumers can identify products and services, giving companies the right to protect their brand identity in the market. Moving on to industrial designs, this protects the aesthetic design of a product. If your product has a unique shape, color, or decoration, an industrial design can stop others from copying it. For example, the iPod's rounded shape and click wheel. The sleek rounded design of the original iPod along with its iconic click wheel is a protected industrial design. Apple's design was revolutionary at the time and is protected to prevent imitation. So industrial designs protect the visual appeal of products, and this kind of protection ensures that businesses maintain their unique product look. Let's also look at geographical indications. A geographical indication identifies a product as originating from a specific place and its quality, reputation, or characteristics are linked to that place. For example, basmati rice. Authentic basmati rice comes from specific regions in India. Only rice grown in these areas can be sold as basmati, preserving its distinct aroma, flavor, and texture. So geographical indications protect regional products and maintain cultural heritage and local economies. They ensure that only products from the specific region can use the geographical name. Next we have trade secrets. These are business secrets that provide a competitive edge like formulas, processes, or designs that are kept confidential. For example, the formula for a Red Bull energy drink. The precise formula for Red Bull, which includes its blend of caffeine and other ingredients, is a trade secret. As long as the secret is kept and not disclosed, it can be protected indefinitely. Trade secrets are crucial for businesses that rely on confidential information to succeed. Last but not least, we have plant variety rights and farmers' rights. These protect new plant varieties that are unique and distinct from existing ones. For example, a new type of wheat that grows faster can be protected by plant variety rights, ensuring that the creator of the new variety can benefit from it. This kind of IP protection is important for encouraging agricultural innovation and supporting the development of new and improved plant varieties. So, there you have it, 7 different forms of intellectual property that play a crucial role in protecting ideas, creativity, and innovation. Each form of IP is designed to safeguard a specific aspect of human creativity, and together they encourage new inventions and artistic works.